what I bring here, I think, is someone who was interested in it when it was, really an unknown field. And as I said, this really came out of going places and people saying to me, what happens to my Facebook profile when I die at parties? It was just a thing. No one had any idea. So I ended up doing a geeky paper or two on it. I think I'm having just done a quick look, one in 2006 that touched on it as part of a general consideration of emerging forms of new virtual property, and one in 2009 that focused explicitly on death and the digital assets after death. So that's 12 years ago. Yeah, is that right? So what I'd like to emphasize, I suppose, are the points that drew me as really a black letter private lawyer as opposed to a philosopher or a psychologist. So this is my orientation, to be the dull person who goes, but, that contract, involves personal rights that expire after death. So, for me, this was originally evocatively an area that was a case study, really, for the tensions between platform control over assets that were produced or edited or published or distributed in that milieu against the rights of the individuals, of the individual users. Those could be rights both of ownership and of access. So for me, these have been continuing themes: contract governance, platform control, ownership. What does it mean in the context of digital assets, especially non-copyright works, and access? I think it's worth mentioning, actually, and Burkhardt will remember this, that this came out of a really interesting general project that we were conducting at the time in Script, what was, I think at the time, not called Script, but became known as Edinburgh, which was called Property, Personality and Privacy. And one of the things we were looking at there were the crossovers between these concepts, which I think at the time was quite a new idea. So we also had copyright lawyers, we also had medical lawyers, we were also interested in data and privacy and information. And so all these ideas were kind of thrown into the mixer. So I had two things that were perhaps slightly unusual. One, that I'd come from actually being a family lawyer, not a practicing family lawyer, but someone who's taught family law for 20 years. And so I was quite interested in what I think has been picked up very well in some of the work like from Casquette, about how society was changing. Succession law was predicated on the idea that what was important was your family, your clan, your bloodline. And this has really changed in the digital age to being about your friends, some of whom you may never even met, and certainly who may be interested in aspects other than inheriting your land to keep it in the family, sort of thing. So that's been a real sea change. And that leads also into a similar thing I was teaching at the time, which was succession and trust law. So I think this is probably a really unusual combo, right? In the same way that at one point I was in for an exam where you had to be good in English, Greek, and athletics. You just get these weird happenstances. So from succession law, I became very interested in the balance of interest between the living contemplating their own decease and the heirs. Yeah. And so you do get to these ideas, which are really nicely discussed in a few of the contributions. I think Jonathan's maybe about, do you have the right to say no when the family subsequently say yes, or vice versa? How do we control this? And that takes you into some of the work that Michael and his team are doing on, do people get it wrong? Do they take steps during their life that actually protect the privacy of their assets such that they can't be distributed or made available to the world after their death and so forth? So this idea of a post-mortem privacy paradox is something that I think is fascinating and is emerging. So what happened? What happened from these early interests really in contract governance, in platform control, in tensions between different heirs, different parts of the family, and indeed people who aren't regarded in conventional law as heirs or family at all? What happened? So a lot of social factors happened, and that's partly what this first session I think was meant to interrogate. So I've written down, our dependence on data in the cloud and platforms has become profound. When I started looking at this stuff in 2006, 2009, people went, well, what does it really matter? You know, it really was something you talked about at parties. People cared a bit because it was interesting, but it wasn't a big deal. But now our entire life is in the cloud, you know, which is something that Christopher and his team can speak to. And obviously, therefore, this tension in power between the platform and the user has become even more notable and is now dominating so many fields. You know, the fields about online harms, the fields about competition, the fields about consumer protection. So, you know, platform governance is the thing of the moment, you know, and you can see this in the in the plank of legislation coming from the EU with the DSA, the Digital Services Act and the Digital Markets Act. In the UK, where we've got a new competition unit that's trying to sort out the power of platforms and their algorithms, etc. So this has become enormous. I think one of the big things I've written down is, I think even in 2006 or 2009, we were very suspicious of the power of Facebook et al. But there were still these vague efforts to pretend we were all a community, you know, to have, there was an exercise in trying to have Facebook rules that we'd all vote on, sort of to feel like a club. But now I think it's notable that we don't trust these platforms at all to act in our interests. And this has maybe given rise to some interesting new phenomena, which I think are raised by a few people, maybe Barbara, as to whether we should be looking more to models of data cooperatives, data trusts. Are there other ways we can deal with these digital assets, digital remains, that take us away from the emblematic power of platforms? So I think that's an interesting theme that's come in. I know as a black letter lawyer that there is still vast amounts of black letter law problems to solve here. In some ways, I feel they are less trendy, and I'm very glad to see the work coming out of the Cloud User Project, for example. You know, so many instruments that I think perhaps are under-examined, like how can we combat platform control using unfair terms legislation, using maybe unfair commercial practices legislation? What about transparency rules? You know, so you see from the Queen Mary survey that there's extremely little transparency in the terms and services about what happens after death. What was it? Something like 70% didn't even mention death of the terms and services of platforms where assets are held or produced. You know, there's lots of contract law that I don't really feel qualified to work out about what happens to terms that personally bind a user when he's dead and then somehow still seem to get invoked as binding in some way to heirs. So that would be interesting to discuss. The final point I've got here, I think, so that was platforms, that was black letter law, is that, yeah, we've moved on from the biggie, the elephant in the room that I haven't mentioned so far is privacy, right? So my own concerns, oddly enough, moved away from property and platforms towards privacy, and I got stuck with being a privacy lawyer for the last 10 years. So why privacy? There's a great deal of historical background here, I think, that people here could explicate, some in the videos, as to why do we become obsessed with privacy and to some extent data protection and personal data, as opposed to personality or dignity or memory. Even though some people here like Uta, I think, and perhaps like Jonathan, might be arguing that these are better lenses through which we can see some way of categorizing and giving rights to people contemplating their own decease. And this gets you into obviously patent differences between legal systems, between Anglo-American systems and continental systems. Scotland sitting there worriedly in the middle, yeah, as a mixed jurisdiction. And I'm a Scots lawyer. It's amazing actually how many people I think here are vaguely Scots lawyers. So yeah, what's our best institution if you were starting from scratch? Would you start with privacy? Would you start with data protection? Would you start with human rights? None of these recognize the interests of the dead. Would you start somewhere else, like dignity or family reputation or a clan system or whatever? And I said that was the 3 points I'd make. The fourth I'll make, I think, just I said I wouldn't, is I think that we have become disenchanted with individual rights as control. perhaps that's just me speaking as a data protection lawyer. And this really ties to what I already said, that I think we're looking for solutions that don't rely on individual exercise of rights, which is doubly or triply difficult with the deceased who represents them. There's no obvious regulator to represent their interests because all the regulators represent the interests of the living. The courts more or less represent the interests of the living. And so, you know, what kind of collective mechanisms might be more useful for us to turn to? And that brings us back to these kind of data trust, data cooperative ideas. And I'll stop there because that's loads, although I had written more. So I think Michael now should come on and give his perspective, and then we'll let you guys talk.
Sure. So thanks. Lilian has provided us with an overview of the substance of the questions at stake. And I would like to, in a very brief comment, just say a few things about a sort of a reflexive research comment. And it's wonderful to see that there's a small but growing community of people all over the, well, Western globe, or northern globe that are interested in such issues. And so far we have seen many legal studies, and we will see more, and that's important. There's new legislation here and there and new cases, and more will follow, and it's important and interesting to follow them and have comparative studies at that point. There are lots of philosophical issues. My entry into this topic was some 15 years ago when I wrote a paper in Hebrew on the rights of the dead in general, because I was fascinated by this, and it was sort of an overview, legal, philosophical analysis of that. But, you know, I have not solved it, not for myself and definitely not for anybody else. So there's much there. Of course, this is a very interdisciplinary group in the real sense, not in just, oh, we have an interdisciplinary research. It's deeply interdisciplinary, and it's wonderful to have here psychologists such as Elaine, and lawyers, of course, and media studies such as Tal and others discussing this topic from very different kind of elements. Where can we take the research forward other than just, following the new cases, new legislation, and deepening the philosophical discussions? Well, I'd say more law and society kind of studies to study the gaps between the law and the practices, which leads to more empirical study. So we have the beginning of that with Chris Millard and Dave Mickles and your team study, and Tal's study, Tal and my study, which is both quantitative and qualitative. We've been interviewing users, Facebook users, and also family members of users who passed away, and some others have done that, of course, in their fields as well. And we will probably all be searching for new kind of avenues to explore this topic from different angles. As we do so, I would like to call all of us in our own research, and more importantly, with the others at stake, to insist on transparency. And I'm thinking especially of Facebook. We approached Facebook, Tal and I have approached Facebook, both Facebook Israel, which is governed from Dublin, of course, but they do have some local offices, and also the global Facebook, wherever they are. And we asked very simple questions, such as how many people have activated the legacy contact in the world and in Israel? And of course, Facebook, which encouraged us to share, did not share anything about that. And I think that as a group of researchers, we have a stake here, and we can insist on Facebook and Google and the others share the data, statistics, kind of not identifying data, of course, but the aggregate anonymous data about such issues, which is crucial. Okay, we are studying a private entity or private entities, platforms, and it's important. So they are not governed, they are not subject to Freedom of Information Acts, but I think we can demand that they share such data. So these were my 2 cents about the research of the topic.